It's 6 in the morning and someone is knocking at your door. You open it and find federal agents standing there. One of them holds up a piece of paper and tells you they have a warrant. The moment they step inside, they grab you and take you away. But was that paper actually a warrant? Are you sure? Imagine this for a moment. You are an immigrant who has been trying to build a life in the same apartment for years. You work incredibly hard, pay your bills under tough conditions. You take your child to school and fight for their future every single day. Then one morning, there is a knock at the door. ICE agents, immigration enforcement officers, are standing outside waiting. They have a piece of paper in their hands. It says warrant. So they have a warrant. And in that moment, you think to yourself, if they have a warrant, they can come in. I have no rights against them here. If I try to resist, I could ruin everything. But wait, most people make a critical mistake right at this point. Because the word warrant does not mean just one thing in American law. There are two different types. One forces you to open your front door, the other does not. And the difference between those two can determine how that morning ends and change the fate of your entire family. So do most people know this difference? No, they have no idea such a right even exists, because nobody told them. Here's what you need to know before ICE agents ever show up at your door. Immigration cases under federal law are not criminal law. They are handled and prosecuted under civil law. This might seem like a technical detail, but it completely changes the outcome. In criminal law, an agent must bring a paper signed by a judge in order to search your home. In a civil proceeding, ICE can fill out an internal form on its own. It says warrant at the top, but because there is no judge's signature at the bottom, they actually have no such authority. And that is exactly where the real issue lies. When you open the door, you do not know which one of those papers they are holding. If you want to stay and protect your family's rights, when that moment comes, you will need the right information. The Fourth Amendment to the Constitution says something very clear. Your home is the most protected place in the world. Whether it is a police officer or a federal agent, the legal standards required to remove you from that place apply equally to everyone. In 1980, the Supreme Court ruled in Payton versus New York that without a paper signed by a judge, no federal or local official can enter your home without permission. And that rule applies to ICE as well. So what does ICE actually carry? There are two types of forms. Form I-200. It says detain this person. It is signed by one of ICE's own supervisors. No judge, no court. Form I-205. A deportation order. Also signed by ICE. Also no judge. These forms give ICE authority to do many things, but they do not do one thing. They cannot force you to open your front door. ICE's own internal training documents acknowledged this for decades. One ICE document stated, an I-200 or I-205 does not authorize entry into a person's home. Voluntary consent must be obtained before entry. But in 2025, something changed. A new internal ICE memorandum surfaced. Dated May 2025, this document told agents, you may enter the homes of individuals with a final order of removal using the I-205. But that decision was immediately met with legal challenges. A federal court in California said, no, this cannot be done because it is unconstitutional. A federal court in Minnesota said, no, this violates the Fourth Amendment. So right now, this issue is actively being argued in court. The rule for the time being is this. Without a judge-signed paper, ICE cannot enter your home. There is one exception. If you open the door or if you agree to let them in, that moment counts as consent and all of your rights are completely erased. This is a critical point in American law. Consent changes everything. One more thing. The Fourth Amendment does not only protect citizens. The Constitution says the people, unconditionally. Undocumented immigrants are included in that. In 1886, the Supreme Court confirmed this in Yick Wo versus Hopkins. The Constitution was made to protect everyone on this soil. Now let us return to real life. What do you actually do in practice? The most common mistake is this: opening the door. When ICE comes to your door, they hold up a paper and say, warrant, and you think, they have a warrant, I can't stop them from coming in, so you open the door. But in that moment, you have given your consent. So what is the solution? Even without a judge-signed paper, opening the door is legally interpreted as granting permission to enter. That is exactly why legal experts all say the same thing. Do not open the door. You can communicate with the agents through the closed door, and you can choose to cooperate from behind it. If the judge's signature is there, you have no choice. You do need to open that door. You need to ask, do you have a search warrant signed by a judge? After that, if they do have one, ask them to slide it under the door or hold it up to a window. If the document slid under the door or shown to you is an I-200 or an I-205, you are not required to open the door. The second big mistake is continuing to talk even after you can see there is no judge's signature. The Fifth Amendment, the right to remain silent, applies to everyone. You do not need to be a citizen. You are not required to answer questions like, where are you from? When did you arrive? Do you have any documents? You can simply say, I am exercising my right to remain silent under the Fifth Amendment. I understand this might feel a little strange, but if you do this and they take you anyway, they will have violated the law to do so. Third myth, ICE does not let you get a lawyer, so asking for one is pointless. This is false information. Because immigration cases are civil cases, the government is not required to appoint a lawyer for you, but you do have the right to hire one, and you also have the right to speak to your attorney before signing anything. And finally, know this. These rights are valid, not just in theory, but in practice. Many immigrants have avoided deportation precisely because they knew these rights. Cases changed outcome because the way someone was detained was proven to be unlawful. Of course, no amount of knowledge can protect you in every situation, but not knowing will absolutely leave you defenseless. Your rights are not useful on the day you learn them. They are useful on the day you need them. But most people are caught unprepared when that day comes. If you share this video with someone else, you might just change their life. Subscribe to Rights Illustrated. See you in the next video.